Hello, everybody. It's Dave Neal, stand up comic, host of Bachelor Nation News, and we have some interesting audio to share with you. The full cross examination of Jane Doe by Clayton Echard's attorneys in his injunction against harassment case. As we know, on November 2nd, 2023, Clayton Echard won his injunction against harassment. We had a breaking news story Thursday evening as that came out. It's important to note that he lost his protective order that Jane Doe got against him. So Jane Doe has a protective order, an order of protection, which is essentially a restraining order, which means Clayton can't contact her in any way whatsoever for 2 years. I'm sure that comes with some physical proximities. Well, he got an injunction against harassment now on her. And this is the first time we're going to have the lawyer of Clayton cross-examining her. Last week, this court date began where Clayton didn't have an attorney, and he was kind of getting swept under the rug by Jane Doe's attorney. I've blurred out an image here just for visuals. This is not Jane Doe. This is Anna Delvey. So this is just a blurred out image of somebody just to paint the picture here for the thumbnail. But I'm going to share with you the audio. I've been made aware of the video. I hear it's scandalous. I hear the reactions are wild. We're just going to share the audio. We don't need to expose Jane Doe here. We're just here to show you what Clayton is working with and the accusations of perjury, the accusations from Jane Doe that he's actually a random commenter on Reddit. We're going to get into that right now. Let's have a listen to it. Again, it's going to sound, the video, there is no video, so just hang tight, fold your laundry, do whatever you need to do. But we're going to hear one piece of evidence that Jane Doe's trying to get into the trial, and then right after that, we'll have the full cross-examination. I'm not going to pause it once. Let's get into it.
Yes, I do.
Okay, and what is it of?
This is something that was posted to Reddit by Mr. Echard under a false name, and that was also in the order of protection hearing I had against him last week. It was discussed.
Okay, and did you change this image in any way?
No, I definitely did not.
How'd you get a copy of this image?
It was on Reddit. Somebody had created it, but I know it was Mr. Echard because only he had this image.
So what she's referencing, and I will pause for this part only, what she's referencing is an image of a baby bump, which is her photo. And she's claiming that it was sort of made to shame her and posted on Reddit by Clayton Echard because she claims he's the only one who has access to the photo. The photo in question, we already know, was posted on her Dropbox, which she made public with really anybody. So dozens, if not hundreds of people had access to the photo in question. So you can already see her evidence right here is very shoddy. She says, he's on Reddit disparaging me, harassing me, blah, blah, blah. That's not the case. Now, why do I bring that up? Because I can imagine this is what she's going to use to say that I created fake accounts in the injunction against harassment case she will have towards me. There's a tentative court date for Cyber Monday, the Monday after Thanksgiving, where I will take my personal time and go to court and answer to some of these same random allegations that I am sure she's going to put out there. Because if anyone has any negative comments about her, she just assumes it's one of her haters, when in fact we know it's just the random internet. That's the internet. The internet does. Okay, so after she gets this denied, it gets into the cross-examination.
Objection. She's testifying, Your Honor, regarding information that she cannot testify about. Speculating.
Right. So she's speculating. She's speculating that the Reddit account is Clayton's without any proof that it's his.
You can have her lay a foundation that she has knowledge of.
Okay. It's your understanding that Mr. Echard posted this picture?
Yes, because only he had the photo and the sonogram I'm holding that's been edited.
I had it too,
Okay.
and so did about 100 other people.
Your Honor, I'd like to admit Exhibit
50.
50 at this time.
Your Honor, I'm objecting. This is inherently unreliable. She's failed to lay sufficient foundation. This was not posted by Mr. Echard, and she's provided zero proof that this was posted by Mr. Echard or further that this was sent to Mr. Echard in this manner.
I'm going to sustain the objection and not admit 50.
Okay, nothing further at this time, Your Honor.
Cross-examination.
Your Honor, before I start with cross-examination, my request would be, if the court's willing to entertain this, that we be permitted to go until noon. And I would be willing to waive closing argument because I do have important questions that I would like to go through, as opposed to presenting the court with a closing argument if the court would allow that.
Well, let's see how we're doing on time.
So that's Clayton's attorney asking the court for extra time to cross-examine. This is somebody who's so hungry for dinner that they say, can I have more time to eat and cherish this dinner? And the dinner being what she hopes would be a great cross-examination.
Thank you, Your Honor. Good morning, Ms. Owens.
Good morning.
You were thoroughly questioned by your attorney at the last hearing in this case on October 24th of 2023, correct?
Correct.
And you understand that you were under oath at that time, and you remain under oath today, right?
Correct.
And you're aware that any false testimony that you provided or provide today could be considered perjury, right?
Yeah, absolutely.
Sure.
And so based on that, Ms. Owens, before I proceed with my line of questioning, do you have any prior testimony that you'd like to correct at this time?
I do not.
I want to make sure.
No,
that you're clear.
obviously, she's not going to say, "Well, I made the whole thing up." You know, that's not going to happen. But it's important to ask questions in a way so that for future hearings, there's no misinterpretation of what was said. Very clear on the record statements here that she still believes what she's saying.
And obviously, it's your position that you are pregnant with alleged twins, correct?
100%. Yes, correct.
What medications are you currently on?
Objection, Your Honor. Relevant, and that's an inappropriate question for this.
Overall, it can be impacting your testimony.
I'm on prescribed prenatals, and I'm on folic acid.
Folic acid is not a prescription.
And I also take lamotrigine for epilepsy.
I guess it could be prescribed.
Is there anything else? Is that your entire list of medications?
That's my entire list because I was taken off of anything else that I was on when I found out that I was pregnant.
And have you been diagnosed with any other medical or mental health issues?
Objection, Your Honor. I don't think that's going into her mental health, going into her physical health, mental health. I don't think that's appropriate for this type of hearing.
Sounds good to me.
Overall, I have a question.
Depression.
Okay, and any other physical health diagnoses?
Epilepsy.
And who provided those diagnoses?
I think we're now over the report of that.
The judge is like, all right,
Understood.
TMI,
I'll move
TMI.
on, please. And how far along are you as we sit here today with respect to the pregnancy?
I am 24 weeks along.
24 weeks.
And when was your last menstrual period in order to calculate your due date?
Objection, Your Honor. I don't think that's appropriate at this time. It seems like these questions are meant to harass my client. She's indicated she's pregnant. She's indicated it's been about a month.
Is her lawyer really bad, or is it me? It seems like this is his first case.
Need to know things about her menstrual period.
I'm going to sustain the objection.
I mean, look, I think it's fair to ask a pregnant woman about her menstrual period when you're trying to lay foundation as to whether or not you believe that she's pregnant or not. Like that's what the cross-examination's all about. Because Clayton can't prove harassment if she is pregnant. You know what I mean? Because if she is pregnant, then she's just trying to message him about co-parenting issues, right? But if she's not pregnant, and again, I'm not a lawyer, this is my sort of commentary on the matter, but if she's not pregnant, then it's like, yeah, tell us your menstruation day, tell us what medication you're on, tell us how it feels to be pregnant. Like these are all sort of questions that you can ask to kind of try to find a hole in her story. That's exactly what cross-examination's for.
I'm sorry.
I said I wouldn't pause.
Can you please provide us with your alleged due date?
February 14th.
Oh, Valentine's Day.
And you testify that there's absolutely no possibility at all that your alleged twins are anyone other than Clayton, correct?
There's no chance they're anybody else's.
But you understand that Clayton has been very clear from day one that he did not have sexual intercourse with you, right?
Clayton was not. If you look at the June 4th message,
Ma'am, these are yes or no questions. Do you understand that Clayton was very clear from day one that it's his position he did not have sexual intercourse with you?
Then the answer is no.
So, what? Of course, she's trying to, muddy this playing field here. Clayton said in an email that we only had oral sex. She redacted that when she shared that email publicly on Reddit. She shared all of the other information, but not the part where Clayton said, "Hey, we only had oral sex." She didn't share any refuting at the time. Now she goes back and says, "No, it wasn't clear at all because later on he said he was pregnant." Well, yeah, that's because after he felt like he was gaslighted into knocking you up. Right? Do I have this right, guys?
And as we sit here today, you have participated in 3 DNA tests to try to prove that Clayton's the father, correct?
Correct.
And not a single DNA test has come back.
Oh, I'm sorry.
Stating Clayton's the father.
Sorry, it was 2 DNA tests, not 3.
Here we
Well,
go.
you indicated at the last hearing that you were providing a sample for the 3rd DNA test to be completed, correct?
But the second one got there was an issue with the transit according to the lab. So, I mean, that wasn't tested. So I can't say that I have had 3 tests that have come back with different results.
I get her point. I get her point, but...
Ms. Owens, you've provided a sample on 3 separate occasions for DNA tests, correct?
Correct, but the second was
Ma'am, these are yes or
I
no
had nothing to
questions.
do about.
I'm not looking for you to elaborate. So
Now,
we'll
part
move on.
of this is also some of the cross-examination technique we saw with Johnny Depp versus Amber Heard, in that part of what Clayton's attorney is doing here is, trying to maintain control and not let Jane Doe ramble with her answers or, yes or no questions, maintain control, and then sort of really try to get under her skin, which you're going to see happens. Now, I've been told from the video that the video's jaw-dropping, the reactions that are being made, but I don't think, as far as we are concerned, we need to share that because, I think the audio will speak for itself.
As we sit here today, not a single DNA test has come back indicating that Clayton's the father, correct?
The samples were diluted, and I'm going back next month, is what I was.
These are yes or no questions.
Ooh.
It's a very simple question. As we sit here today, you have no DNA test that indicates that Clayton is the father, right?
The results, the testing is ongoing, is what I was told, as was Clayton.
Yes or no?
So
So
you
that's not
said that on a couple occasions, that the testing is ongoing.
correct.
So is it your testimony that you provide these samples and that there's no results that are coming from these samples you're providing?
I'm unclear on what you're trying to ask me, because they said that I need to go back next month to give another sample, that the testing is not back. So I'm unclear, I guess I'm trying to say.
Isn't it true that the test came back and indicated there was 0 fetal DNA?
That's absolutely not true.
Okay. And again, Ms. Owens, you have provided no testimony and no objective evidence or documentation to date to support that you have a positive DNA test proving Clayton's the father of your alleged twins, right?
The testing is ongoing. I'm unclear, I guess, is what you're trying to ask me.
You don't need to know. She's going to get to it.
Who is your OBGYN?
Dr. McCool
Your Honor, again.
and Dr. Higley.
Her lawyer objects.
Your Honor, I wasn't able to hear that, and I'm not sure if that's
I'll withdraw the objection now.
He withdraws the objection.
Can you please repeat that, Ms. Owens? Who is your OBGYN?
My main OBGYN is the perinatologist, Dr. McCool.
Dr. McCool.
And when is the last time, well, you said your main OBGYN. Who else are you seeing? What other pregnancy-related doctors are you seeing?
Dr. Higley, who I saw last Friday,
Question mark?
and an epilepsy doctor as well for it. He specializes in pregnancy.
Okay. And in your exhibit, I believe it was 44, you indicated, actually, let me go back here. I apologize. It was your exhibit 43. You indicated that all of exhibit 43 contains copies of your medical records that would support this alleged pregnancy, correct?
I believe it was exhibit 46 that was the proof of pregnancy. We didn't do exhibit 43.
Okay, so they're getting to the proof
I
of
apologize.
pregnancy.
Exhibit 46, my mistake.
Her
And
hard
in that exhibit 46,
proof.
all that you have from Dr. McCool here is a screenshot of an upcoming appointment for Monday, July 24th of 2023, right?
Correct. Because he's a doctor.
So part of her evidence that she's pregnant is a doctor's note of an appointment. This again would have been 4 months ago. When you're pregnant with twins, you might be considered high risk as they're twins, and you might be going to the OBGYN every 2 weeks, maybe, at the very least every 4 weeks. By all means, this is a big deal here. Where's the paper trail?
Understand that anyone can go online at AMOMI, where Dr. McCool works, and make an appointment for an OBGYN.
Whenever we hear, just imagine there's this jaw-dropping person on the other end. We're not going to get that video.
Appointment with Dr. McCool, correct?
That is not true. Dr. McCool is a perinatalist. I have a referral to see him because I have epilepsy. He's a high-risk specialist. You can't go and make an appointment with him. I had to send records to get an appointment with him.
Okay, but the only record that you have provided this court with regarding your alleged high-risk perinatologist is a screenshot of an appointment for Monday, July 24th of 2023,
Yikes.
right?
No, I provided the last page was October the 11th with the diagnosis epilepsy during pregnancy from my neurologist after an appointment that day.
And this is the information she sent to me and countless others. So before she gets her panties in a twist here that we're sharing all of her HIPAA rights or whatever, she sent this information. She sent notes from a neurologist that say she's pregnant. Again, that doesn't mean the neurologist believes she's pregnant. That means that's what the neurologist wrote down that she said to them, that they're not testing for the pregnancy as far as I'm concerned. At least this isn't evidence that proves that. And folks, you have to remember, these are simple cross-examination questions here. This is a good process that we're getting to watch. This is our country's democracy working right here. That someone can say someone else is harassing them and prove evidence, and then you can look at the evidence. And, it's funny that she's getting an injunction against harassment on me because I question her evidence. Imagine if I wasn't allowed to question her evidence. You know how dangerous that would be?
Ms. Owens, there is no copy of any medical record from October 11th.
Yes, there is the last page.
2 more minutes.
It's October 11th. If you look at the last page, Zeman Glynis on October 11th, 10:53:20 Mountain Standard Time.
I apologize. What was it that the court indicated?
A few more minutes, so we need to probably step it up a little bit if you want to get to other things.
As we sit here today, Ms. Owens, you have refused to sign any sort of HIPAA release so that Mr. Echard could obtain directly from your medical providers evidence to support any alleged pregnancy.
No, on Friday, I literally had the doctor send it to him directly.
And this is where it gets crazy, right? So she says, I had the doctor send it to him. And he's saying, no. We want to be able to contact the doctor. We want to be able to contact them, not have them send us things because the trust has been broken down on who they're actually talking to.
My provider sent it to him directly. And that's an email I sent to him telling him that it was sent directly to him. I signed a HIPAA release.
Ms. Owens, this is not the first time that you've made allegations that you're pregnant with twins within the last 2 years.
Wow.
Correct?
That is incorrect.
Okay. So I would ask the court to take judicial notice, Your Honor, of the civil matter involving Mr. Greg Gillespie, who is present in the courtroom today.
Wow.
And it's CV.
So Greg Gillespie is present in the courtroom. That's another man that allegedly claims she made up that she had twins with him. So the Clayton's lawyers are trying to present this copycat case and say, look at the similarities here, which is very difficult in the courtroom to bring in past court cases. You're supposed to judge something on the merits of what it is, but if there's some sort of, and again, I'm not a legal expert, so please correct me, all my esquires in the comment section, but if there are cases in the past that have the same sort of handwriting as a metaphor, then you can say, well, she crosses her T's this way, she accuses these guys of doing this way, and then they can piece that together. But it's up to the judge right now to decide whether or not she wants to open up that can of worms. They're short on time. This is how the court system actually works, where everything, it's over, not enough judges, it's too bad. It's too bad they don't have a full day to flesh this out.
You get that number for the court.
I have a protective
2021
Gillespie and against Mr. Echard, and I wish I was aware that Mr. Gillespie
052.
She says, I have a protective order against Mr. Gillespie and Mr. Echard, and that she wishes that she was made aware that he was in the courtroom. I mean, the truth is, it's a public courtroom. He's allowed to be in the courtroom. I'm allowed to watch this. This is how it all works. And for those that aren't familiar, there actually is, I was sent the rules here to make sure I won't be bullied into not sharing this. The sealing and unsealing court records, Rule 5.4 in the the code book here, 5.4, sealing and unsealing court records. Unless authorized by statute, rule, or court order, no document may be filed under seal. This case was denied seal, and even though it wasn't live streamed, it was made public for anybody and everybody to listen to. So let's continue on here.
2893.
No, I'm going to object to that.
We had an exhibit that we discussed last time regarding that case, and what was presented was a complaint and a motion to dismiss, and there wasn't any findings from any court on anything related to that. So I'm not going to consider that at this point.
Your Honor, I do have some questions that I think are very important.
So as far as I can tell there, the judge is saying there were no findings from that previous court case that said one way or another whether or not she was pretending to be the unborn. So this is where it gets very complicated, because she says, I won that case, he made it up, X, Y, and Z. I don't have enough information on that case, and it seems like the judge also doesn't have enough information on that case to say one way or another what the actual outcome was. I truly don't know. All I know is what Jane Doe has told me, which is that she won the case and he's out to get her, and all of that.
For the court to hear regarding that case, I understand if the court doesn't want to take judicial notice, but I do have questions that are important that I would like to proceed with regarding the uncanny similarities.
I don't think that would be appropriate for this specific hearing. We know the scope of this particular hearing. Bringing up things in a separate case, there's separate issues. These are not the same thing. This is an injunction against harassment. I don't even know what that case is. It's not an injunction against harassment. I know that.
So he says, I don't, this is Jane Doe's lawyer says, I don't even know what that case is. And you're going to hear in a few minutes that he actually knows very well what that case is.
Your Honor, this goes to the heart of why Mr. Echard needs this injunction against harassment, and Miss Owens' pattern, her modus operandi, her pattern of behavior, her pattern of making the same claims against other men in the state of Arizona within the last 2 years. And I think it's highly relevant to this case because it supports why Mr. Echard needs this injunction against harassment, because this individual has done this before, and there are concerns that she will not stop.
Wow.
I'm going to sustain the objection. I'm not going to allow that testimony.
Oh, so she doesn't allow it.
And Your Honor, I would ask, again, the court to reconsider here.
Wow. So this is big, right, for a lawyer to say, I would ask the court to reconsider. This is big that Clayton's attorney, for multiple reasons, says, please reconsider this. This is our whole case here is showing these similarities.
Important that the court hears how Ms. Owens has made the exact same allegations in another matter within the last 2 years, and that she has committed perjury in her the last hearing because she made she made false statements under oath regarding the nature of that case. She opens the door in her testimony when Mr. Lopez was when he was direct examining her regarding the fact that there are no other cases that are similar regarding things that happened in that case. So she did open the door based on her direct examination.
Wow.
These are very serious allegations that the petitioner's attorney is now alleging against my client.
He sounds like someone pretending to be a lawyer. Your Honor, these are very serious allegations. He's just like reading off of like what to do when you're, I don't know. No offense to the lawyer here. Maybe we'll be hearing from him. But it seems like I don't know if he wants to be a part of this case.
She is insisting that my client has now committed perjury. My client has no criminal history and is not being charged with perjury. So
Not yet.
I don't know. That's just an allegation. Again, these cases are completely different.
We're hearing that these cases are completely different. I mean, look, he's getting mopped. He's getting mopped over here by Clayton's lawyer. Agree or disagree? That's my opinion. Leave a comment.
The attorney testified that these are the same. These are not the same matters. These questions and this cross-examination of my client regarding these issues, again, would be inappropriate and is outside the scope of this hearing. In fact, it even sounds like she's trying to bring out character evidence, which would be inadmissible in a hearing like this.
A+.
I'm going to sustain the objection again. So if there's other things you want to ask about her testimony, okay. You have about 2 more minutes.
2 more minutes to cross-examine Jane Doe.
Ms. Owens, you understand and you testified under oath that Mr. Echard blocked you from communicating with him, correct?
He would block and unblock. But not from communication. It was on a text number, but we were always in email communication as recently as the day before I went to the press. He sent me an email. So.
Wow, at least she admits she went to the press. She's never denied that.
Well, Mr. Echard told you he didn't want you contacting him anymore and then would block your telephone number, correct?
But he unblocked
But told me to email him.
Because?
Ms. Owens, these are yes or no questions. Isn't it true that Mr. Echard indicated he did not want you contacting him anymore and then would block your telephone number?
Yes.
Actually, that's incorrect from the early
say no.
resolution conference that we had. Mr. Echard told me specifically to contact him via text. I had forgotten that. If you look at the transcript from that hearing, you would see that. And I haven't contacted him via text after he told me to.
Okay, can you take a look at Exhibit 55 for me, please?
I don't have an Exhibit 55.
Oh, boy.
Your Honor, these are our supplemental exhibits.
But we're not.
Than the ones that are their exhibits that they would have sent you.
Shit's about to hit the fan, guys. It's hitting the fan. So she's on Skype, right, or Zoom. She's not there.
It may not be marked by number. I guess the issue. Hers may not be marked by number.
And she says she's not there because of the protective order, which she just got against Clayton. But, of course, she was in court with him a few days earlier. And that, therefore, the digital BS that has to go on here, where does she have the exhibits? Does she not?
Let me check my email.
And then the clock's draining. They only have so much time. They can't find the thing. Every question matters.
Did not see his exhibits. Excuse me. Let me...
And Your Honor, I'm asking for more time because her not being prepared, knowing I presented these exhibits to her attorney yesterday, is coming into my time, and I have still several questions I'd like to ask.
Oh, whoa.
I was not aware that he was getting more exhibits added after he already had testified, so I apologize. There's text messages between the parties dated 5/23/25, that's all I have. I don't have the actual exhibit.
That's the first one. and then there is another one after that. Do you see?
Scroll down. You'll find it. Riveting stuff, folks. I didn't want to skip any of this. You got to hear the whole thing.
You have the exhibit that's from May 25th?
Just wasting time.
I don't see anything. I literally just am seeing a list of plaintiff's trial exhibits.
Scroll down.
55 through 63.
Just scroll down. You'll find it.
Can you explain what the context is for me to understand?
Are you able to scroll down?
Even her lawyer's like, scroll down.
Your Honor, I'm concerned if she doesn't have these exhibits that we're going to need more time, because this is very important that I get through this testimony, and I provided these to counsel in advance to avoid this exact issue. And had Ms. Owens been present, this wouldn't have been an issue at all.
Whoa.
Right, but I have a protective order against Mr. Echard.
All right.
And by the way, I mean, we weren't in the room as to why she got the protective order, but I do believe, and I haven't seen the documents, but coming from my lawyer, I do believe she was rejected in the protective order she got against me. Now that's what she tries to do. She tries to get and this is just the playbook that I'm seeing. She tries to get the protective order, and then that way she doesn't have to show up in person. And then she's able to say, well, I can't do this because I got a protective order. And then that's kind of like the minor league baseball sort of bracket system that she has going here.
Can you find the exhibits or not?
Those are my opinions.
Let me just try to see if I can scroll down. Hang on, maybe if I make my screen smaller.
Yeah, scroll down. You'll find them.
Oh, yes, I do.
There
Hang
they
on.
are.
I think
All right,
I
we
see
got
them.
them.
I see
Your Honor, we have the exhibit.
55. Yes, I do.
Allow us 3 more minutes, please.
Go ahead.
Ms. Owens, do you see Exhibit 55 is a text message communication between you and Clayton dated May 25th of 2023, correct?
Correct. The day after he didn't file the...
I would move to admit these exhibits, Your Honor. This exhibit.
It's not testimony. She's asking if you recognize the exhibit. Any objection to 55?
I don't remember sending
I'll
it.
admit 55.
And here, Ms. Owens, on May 25th of 2023, Clayton says to you, I'm debating filing a police report. Please leave me alone, correct?
The context needs to be stated. He did not make
Ms. Owens, I am
$1.1
asking
million
you yes
for
or
me.
no questions.
And he was found in
Your
violation.
attorney will have the time to ask you a question again, Ms. Owens.
The judge is
just
over
answer
it.
her question, and your attorney will have an opportunity to question you again.
Because the judge is not going to like that Jane Doe is not following court procedure here. Not going to like it. Like, she'll get the time after, but this is the cross. This is Clayton's lawyer's time to ask questions to get things on the record.
Okay, then can you? I'm sorry. Can you repeat the question? I'm sorry. This is ridiculous.
Your Honor, I'm concerned that she's doing this intentionally to eat into
All right,
my
let's
time.
just ask the questions. You're wasting more time saying all that stuff.
Ms. Owens, isn't it true that on this text message dated May 25th of 2023, Clayton responded to you and said, I'm debating filing a police report. Please leave me alone, correct?
That's what the text message says. I don't have that, but sure.
And
that's what
right
it says.
below that, you sent him another text message, correct?
That's what it shows. Correct.
Okay.
This is 6 months
Can we
ago.
move to Exhibit 56? It should be the next page of the document, please.
Your Honor, how are we on time? Because I knew you said 3 minutes. I understand.
We're close
Oh,
on time,
shut
so-
up. Jane Doe's lawyer. What a snitch.
Your Honor, I feel like we're late for lunch, and if I don't get my fiber intake, Mom's going to be very upset.
Oh my God. And it seems like the judge has already made up her opinion, because Clayton's lawyer is saying, I would like to have more time here. And the judge is like, just get through it. We're going to we'll get everyone their opinions made in a second. But, okay. We're almost done, folks. All right.
I want to leave everyone time to do a closing if they choose to.
You see these emails between you and Clayton dated June 28th of 2023, correct?
Correct, but the middle email is missing from him. But correct, yes.
You're going to move for the admission of Exhibit 56, please.
But it's missing
Objection
the
56.
middle
Yeah, Your
email.
Honor, I'm going to object because this
You got it.
isn't everything in whole. You can see that there's an email missing between these two emails. There wasn't any foundation that was laid.
But this was one of many emails sent between the two of us. Clayton changed his mind many times.
I'm just referring to these exhibits. Do you recognize these exhibits? These messages?
I mean, that's what they said. I haven't gotten to read through them, but I mean, that's what it says.
Yes.
Do you believe these are a representation of the exhibits or of the emails that were sent?
I know that my name when I email somebody else has a picture of me with a horse instead of the LO, so I don't know if that's relevant, whereas like Clayton's picture is shown with Clayton Echard, so I don't know if that's relevant. If I read these quickly, I can see if they are mine. I'm going to trust that they are mine, but I haven't gotten a chance to read through them.
You haven't got a chance to read through them? This is your big court case here. Just a couple emails.
Your Honor, she did testify that she recognized these to be emails dated June 28th of 2023. So I'm asking for their admission.
All right, guys.
Again, the middle email is missing where Clayton tried to trap me. But
tried to trap her.
Your Honor, I'm asking if the court strike that there's no question before her right now regarding that.
I'll strike that statement. I will go ahead and admit Exhibit 56.
Clayton's lawyer goes, we didn't even ask her a question.
Ms. Owens, on line 1, you say, I just need clarity as to what we are doing. I've offered to give you control over the outcome of the pregnancy if we date exclusively and care for each other, correct?
So this is interesting. They show the email where they show the email here where Jane Doe says, I'll give you control of the pregnancy if we date.
Correct, which was one thought on one day, and I took that away after.
And she said, correct, that's a thought I had. Let's play that one more. I know it's a long one, but let's play that one more time.
There's no question before her right now regarding that.
I'll strike that statement. I will go ahead and admit.
This is very fascinating. Just listen to this one more time, guys.
In Exhibit 56, Ms. Owens, on line 1, you say, I just need clarity as to what we are doing. I've offered to give you control over the outcome of the pregnancy if we date exclusively and care for each other, correct?
If we date exclusively and care for each other, I'll let you decide if you keep my babies or not. The threats are wild here, folks. Wild. And she doesn't deny it.
Correct, which was one thought on one day, and I took that away after, yes.
It's yes or no question.
And this is the exact same statement that you made to Mr. Gillespie back in
Objection,
July
Your
of
Honor.
2021, isn't it?
Where's the objection?
I have no idea what statement I made to Mr. Gillespie, but both...
If I was Jane Doe's lawyer, I would have objected there because they're bringing back testimony that the judge said that was inadmissible. But either way, I don't know a thing about this, guys. I'm just a stupid Bachelor commentator. But very interesting that Clayton's lawyer is trying to draw the uncanny terms that she used, comparison, that she used the same gotcha pregnancy to keep people dating her.
Pregnancies have been medically proven, and I have the documentation and sent it.
But Ms. Owens,
all right, we can't keep everyone talking over each other.
I sent the HIPAA records. I released my HIPAA records.
Ms. Owens, there's no question before you. Your Honor, I'm asking the court to strike these statements.
All right, so...
And then she goes, how dare they not let me talk my way out of this?
Let's try to just answer the question.
I don't know what I said in 2021.
Okay, so if you don't remember, just say, I don't know what I said.
I don't know.
That if I said that. Okay,
I don't know.
There we go.
Yeah.
All right, so we have room for one more question, and we're going to be doing closing argument.
And Your Honor, again, I would just ask that in lieu of closing argument that I be permitted to ask.
I've already done that. Okay. We're already at 11:56 at the moment. So,
okay, Your Honor. And here, Ms. Owens, isn't it true that you alleged you were pregnant with twins with Mr. Gillespie in June of 2021?
No, that was an email that he doctored in 2021 that I have already testified about that in the other case. So no, I never said I was pregnant with twins.
So she claims that the previous guy doctored the email that said she had twins. So now it gets spilled into the whole, like, do we have forensics over whether or not the email was doctored? This is kind of where it gets muddy. Is the judge able to, and this is one of those cases, the court system just doesn't have the bandwidth to deal with all of this.
Can you please take a look
Again,
at our exhibit?
This was an exhibit that, whatever it is, I'm guessing I know what it is. It was one message that was doctored by Mr. Gillespie that appeared a year into the court case I had with him.
Right. And we've already discussed the fact that I'm not really considering all of that. So let's move to closing.
Your Honor, my concern here, and again, I mean this with all due respect, but Ms. Owens has a pattern of behavior here. She has previously made identical allegations in another case. The exhibits that I have today, as supplemental exhibits, all support that the statements she's made to Mr. Echard are almost identical to statements made to Mr. Gillespie in 2021. This is highly concerning behavior. She has now perjured herself on several occasions during testimony, and I am not being given the opportunity to show the court the documents to support that she is lying under oath.
I have proven my pregnancies and had my records sent to Mr. Echard.
Okay, Ms. Owens, Ms. Owens, we're not testifying right now.
I'm sorry.
Babe, shut the door.
Even if it was true
in a hotel,
that
guys,
Ms. Owens did that in the past, which we are denying, but even if it was true, that has no relation to this specific case. Just because she may have done it before doesn't mean she's doing it now. And we have presented evidence showing that she is pregnant. We have presented evidence showing why she is.
False.
We're going to do closing arguments now. So whoever wants to do it.
All right, so then they go to closing arguments. How apropos that as we finish the cross-examination of Jane Doe, my wife flushes the toilet in this all-too-small Hyatt hotel. She's laughing. You hear that shit swirling down the toilet? That's not just testimony. That's my wife. Okay, very funny stuff. I made her laugh. That's always good. Hey, it's all fun, folks. You thought that was you were like, oh, Dave's got a toilet flushing in his soundboard. No, that's just crystal clear audio from a Hyatt place. All right, and anyway, folks, that's going to do it for our Jane Doe cross-examination. It's fascinating. It's also relevant to know that the lawyer that Clayton hired here is the same law firm that represented Greg Gillespie. So they know, or at least it's of their opinion, that she is perjuring herself, which is lying under oath here, which, you could be convicted of, if you're convicted of perjury, you could serve jail time over that. But they're saying she's perjuring herself because she's not telling the truth. Now, this is where it gets complicated because I don't know what the court deemed true or false in the previous testimony, and that's where it gets all complicated here. And I think that's why the judge said, hey, you know what, I don't want to deal with previous testimony, let's just get to the facts here. And it appears as though the judge sides with Clayton Echard. I'm going to share that in the next video because this is getting extremely long. But look, what, you want me to give you a 7-minute version of this, folks? No, this is the type of stuff you have to listen to. I will not be accused of only cherry picking information. I just shared with you the full cross-examination of Jane Doe, and there you have it. I offered my opinions, and damn it if I'm going to get in trouble for sharing something publicly where I offer my opinions. I'm not forcing anyone to feel a certain way, and I am certainly not forcing anybody to harass Jane Doe. We do not condone any harassment whatsoever. No need to look her up or find her or this or that. Just take this case for what it is. For all of my fans and audience out there, let's be a pro-Clayton Echard opinion. Again, until the evidence proves otherwise. If the evidence comes out where I see an ultrasound that's clearly hers, she's in the room, I see the babies, 2 babies' hearts moving. They're playing a patty cake with each other in the womb. Until we see any of that, I can't necessarily trust my intuition to believe anybody right now. So that's where I stand. I'd love to know what you think, and we'll be back with more content right after this.